Trump administration withdraws defense and Biden-era non-compete ban. In a pivotal shift in U.S. labor and antitrust policy, the Trump administration on Friday dropped its legal defense of a rule introduced under former President Joe Biden that sought to ban employee non-compete agreements nationwide. These agreements, signed by over 20% of American workers, prevent employees from joining rival firms or launching competing businesses. The U.S. Department of Justice filed motions in federal appeal court in New Orleans and Atlanta to dismiss challenges against rulings that had struck down the 2024 Federal Trade Commission regulation. By abandoning the appeal, the administration effectively ends judicial scrutiny of whether the FTC has the authority to enact such sweeping labor market reform. The decision, though anticipated, underscores a decisive policy divergence. FTC Chairman Andrew Ferguson, appointed by Trump and a long-standing critic and the ban, confirmed earlier this year that the agency was reassessing the rule. Ferguson and other Republicans argue the FTC's regulatory powers are limited and not to extend to blanket prohibition, framing the non-compete debate as a matter of statutory overreach. Business group including the U.S. Chamber of Commerce alongside companies in marketing and real estate had led the legal opposition. They contend that while certain clauses in non-compete agreements may warrant scrutiny, the agreements themselves are lawful tools to protect corporate interests and investment. The Biden-era FTC, however, defended the rule as a necessary corrective to market inefficiencies, asserting that non-competes stifle labor mobility, depress wages, and curb competition. The rule's abandonment now marks a setback for labor advocates who hailed it as a landmark reform for American workers. Signaling a more restrained approach, the FTC under Trump announced its first enforcement action of his second term this week, a settlement with the country's largest pet cremation company, preventing it from enforcing non-compete agreements with 1,800 employees. The cause illustrates a narrower case-by-case enforcement strategy rather than a sweeping nationwide prohibition. The withdrawal of appeals highlights the broader philosophical divide between Biden's regulatory activism and Trump's market-oriented realpolitik. Now, with non-competes continuing to affect a substantial portion of the American workforce, the debate over worker freedom, corporate protection, and the FTC's authorities is far from over.